A court ruling just dropped that can change what legal carry looks like for millions of people. And the crazy part is, most gun owners won't hear about it until after someone gets jammed up. Quick question before we continue. Are you subscribed? Because what I'm about to reveal could save you from a decade in prison. Hit that button now. All right, let's talk about what just happened in plain English. A federal appeals court looked at California's rules on open carry and said, "You can't block open carry this way." The case is about a regular citizen who wanted to openly carry a handgun for self-defense, and the state had a rule that shut open carry down in most places where most people actually live. Here's the key detail that makes this story so important. California had what people call an urban open carry ban. It used a population cutoff. If your county has more than 200,000 people, open carry was basically a no-go. That covers the huge metro counties where the vast majority of people live. Now, before you run to the comments and type, "So, open carry is legal everywhere now?" Slow down. Court rulings don't work like a light switch for your daily life. A ruling can be appealed, it can be paused, it can be narrowed. And even when you're legally right, you can still be the one standing on the sidewalk in handcuffs while a court fight drags on. That's what this video is about. Because this one ruling didn't just change a law, it changed the battlefield. And it creates 7 big shifts that affect how gun laws are enforced, challenged, and rewritten from this point forward. So let me break this down for you, like I'm talking to a friend. First thing, the word changed in my title doesn't mean 7 laws got erased overnight. It means 7 things just shifted in the real world. What can be enforced, what will be challenged next, and what mistakes can get you in trouble if you're not paying attention. And trust me, the part nobody's talking about is not the headline. It's the ripple effect. Change number 1. Big area open carry bans just got a lot harder to defend. Here is what the court basically said. If a state wants to ban a common way of carrying a firearm in public across massive real-world areas, the state needs a strong historical reason. Not a modern fear, not a political argument, not a public safety speech. History. In other words, the government can't just point at cities and say, "Too many people here, so no open carry." Now, why does that matter if you don't live in California? Because if courts accept this reasoning, it becomes a tool, a blueprint. It means other laws that block carry across huge zones can be attacked next. And it also means states might start rewriting their laws right now to avoid being the next target, which leads to the next change. Change number 2. Open carry and concealed carry are not being treated like the same thing over here. Most people think this is simple. They say, look, if the state lets you concealed carry, then banning open carry is fine. That sounds logical at first, but the judges in the majority didn't treat it like that. They treated open carry as its own protected category, not just a style choice, like it matters, legally, whether the state lets you carry openly or forces you to hide it. Here's why that matters. Because a lot of gun laws are built on trade-offs. They say, we'll ban this kind of carry, but we'll allow that kind of carry. If courts start saying, nope, you can't just swap one for the other without strong proof, then states lose an easy excuse they've used for decades. Now, the part that shocked me is what comes next. Change number 3. Legal on paper is no longer good enough if it is impossible in real life. Let me explain. Some states love to say, we don't ban carry, we just require a permit. But then they make the permit process so hard that normal people never get one, or they can't figure out how to apply, or the local office drags its feet for a year. So it's legal, in theory, but denied in practice. This ruling shines a spotlight on that trick. Because when the court looks at a system and sees that it blocks real people from carrying in real places, judges start asking different questions. Not, what does the law say on paper, but what does the law do to people? Here's a hypothetical example to explain this. Imagine you live in a county where the website says you can apply for an open carry permit, but the phone number never answers. The office tells you, we don't do those, or they require appointments that are booked out for 12 months, or they say you need a special reason even when the law claims it shall issue, meaning the government must issue the permit if you meet the checklist. On paper, that's a permit system. In real life, that's a ban wearing a suit. Now, if you're thinking, okay, but how does this affect me tomorrow morning? Here's a real-world scenario that should make you sit up. Imagine you're driving through a county line. One county has one set of rules. The next county has another set of rules. You stop for gas, your firearm is visible, somebody calls it in, a deputy shows up. Even if you're sure you're right, you might spend the night explaining it. And that's why you can't treat these changes like internet trivia. Because the consequences are not a comment section argument. The consequences are arrest, a criminal case, and losing your rights. Now this is where it gets interesting. Change number 4. This ruling pressures states that rely on panic and chaos arguments. States often justify open carry bans by saying people will panic. They'll say it could create chaos in public. They'll claim it's unsafe because someone might misunderstand what they're seeing. Here's what's different now. The current test in major Second Amendment cases focuses on historical tradition, so fear alone is not enough. A state can't just say, well, we think it's scary, so we ban it. They have to show that similar restrictions existed in American history in a similar way, for a similar reason. That's a big shift, because it forces states to argue like historians, not like campaign managers. And that also means they have to defend their laws with facts, not feelings. Now, this is the moment where I want you to check your own assumptions. Have you ever thought, if I'm legal, I'm safe? Because that's the mistake a lot of people make. Being legal does not always mean being safe from the process. If your local agency doesn't agree, or if the state is appealing, you can still be the person who gets dragged into the system, even if you win later. Now, let me give you a practical way to think about this. There are two kinds of gun law changes. One is a clean change, like a law passing with a clear date. The other is a court change, where the law becomes a moving target because it depends on appeals, timelines, and what local agencies do while everyone fights it out. This ruling is the second kind. And those are the changes that get people in trouble, because they create confusion. And confusion is where mistakes happen. If you're finding this helpful, imagine what you'll learn in my next video about the 5 words that protect you when cops ask about your gun. Subscribe so you don't miss it. Okay, now we're around the point where people start asking, so what are the other changes? You said 7. Here we go. Change number 5. This ruling becomes ammo for challenges against carry bans in disguise, including massive restricted zones. Even if your state doesn't use an open carry ban, it might use a different tactic. Some states respond to court rulings by creating giant no-carry zones. They might call them restricted areas. They might call them sensitive places. They might ban carry on broad categories of property like all public transit, all parks, all government buildings, all places with alcohol, all places with crowds, all places with events. And what happens then? Your permit becomes a paper trophy because you can carry, but you can't carry anywhere you actually go. Now, I'm not saying this ruling automatically deletes those rules. I'm saying it gives lawyers and judges a stronger argument to attack them, because the logic is similar. If the government blocks normal public carry for normal people across huge areas, courts may start asking, is that really consistent with the Constitution? And once courts start asking that question, states start getting nervous, because lawsuits get expensive, and losing cases creates new precedents. Change number 6. This ruling increases pressure on states to stop playing county-by-county games. Let's talk about something that sounds boring but affects real people. Patchwork rules, county lines, population cutoffs, special local restrictions. Most people don't think about that stuff until they travel, or until they move, or until they on the wrong side of a county line and don't even realize it. This ruling attacks the idea that a state can take a right and shrink it down by geography. It says, in effect, you can't just decide the right disappears where most people live. Now, that doesn't mean states won't try new tricks. They will. But it means those tricks have a weaker foundation now, at least in the areas covered by that federal court. And once again, even outside that area, lawyers use these rulings as persuasive support. Change number 7. This ruling sets up a high-stakes appeal fight that could change the national map. Here's what most people miss. A 3-judge panel decision can be the start of a bigger fight, not the end. The state can appeal. The state can ask for a bigger group of judges to review it. And while that happens, the legal reality can be messy. So your biggest risk right now is not just what does the ruling say? Your biggest risk is assuming the dust has settled when it hasn't. That's how people get blindsided. Now I want to give you a simple checklist mindset. Not legal advice, just common sense for staying out of trouble. First, never rely on social media for what's legal now. Social media is always late, always loud, and often wrong. Second, if you're in a state impacted by a ruling, track what your state government is doing next. Appeals matter. Third, if you carry, build the habit of checking the rules before you cross state lines or county lines, especially if you're traveling through states with complicated carry laws. Fourth, if you're unsure, don't test the system. The system is not a quiz, it's a machine, and it will crush you financially even if you're right. Now, quick legal note. This is educational information, not legal advice. Always consult an attorney for your specific situation. Let me make this super real with one more hypothetical example. Imagine you're a normal, law-abiding person. You have no criminal record, you're just trying to protect yourself. You hear online, open carry is back, so you strap on your handgun and go to a coffee shop. But your state is appealing the case. Or there's a temporary pause on enforcement changes. Or your city has a separate rule about certain locations. Now you're not a gun owner going to coffee. You're the defendant in a criminal case. That's not fear-mongering. That's how the process works. Even when you eventually win, you lose time, money, stress, and possibly your job. And this is why I'm telling you about this right now, while most people aren't. Hey, 73% of people watching right now aren't subscribed. Don't be part of that group. Join the 50,000 gun owners who get these updates first. Click subscribe. Now, before we close, I want you to understand the bigger theme behind all of this. Gun law is no longer just about what the legislature passes. It's also about what courts allow. And courts right now are forcing states to justify restrictions using history. That means the next few years can bring a lot of changes fast. And if you're not tracking those changes, you can accidentally step into a legal trap. Because the law doesn't care that you didn't know. The law cares what you did. Now, I promised you the part nobody's talking about. Here it is. When a ruling like this drops, states don't just give up. They adapt. They rewrite. They shift the restriction from one place to another. If they can't ban open carry in big counties, they might expand restricted places. If they can't use population cutoffs, they might use permit conditions. If they can't win with old arguments, they'll try new ones. So the real win is not just a court opinion. The real win is you staying ahead of the next move, because that next move is what can affect you in your daily life. This information could literally expire after January 2026. Subscribe now, because the next video explains exactly what you need to do before that deadline hits. All right, last 30 seconds. Here's the takeaway. A federal court just said you can T-wipe out open carry for most people just because they live in high population counties. That's a big shift, and it will trigger appeals, new laws, and new lawsuits. If this channel has helped you even once, subscribe. Not for me, for you, so you don't get blindsided later. And simple legal disclaimer, I'm not your lawyer. This is general educational info. Laws change by state and by case. If you need advice for your situation, talk to a qualified attorney in your area.